On Monday, April 14th, John offers to build Paul a conservatory for £5,000. On April 15th, Paul puts a letter in the mail saying yes. 3 days later, on April 18th, John sends a letter canceling the offer, but Paul's acceptance was delayed and doesn't arrive at John's house until April 28th. Identifying whether a contract exists requires us to find the specific point in this sequence where a valid offer was met by a binding acceptance. For that to happen, 3 elements must align: agreement, comprising a valid offer and acceptance, consideration, and intention to create legal relations. Determining the outcome of this timeline is a matter of filtering these events through a strict sequence of binary legal doctrines. This analysis begins by discarding the idea of a meeting of the minds. In contract law, the genuine private intentions of the parties are secondary to their outward behavior. The court in Smith v. Hughes established that we apply an objective test. We judge the agreement based on what a reasonable person would conclude was happening based on the words and conduct exchanged. If a seller intends to ask for £6,000 but accidentally texts a price of £5,000, they are bound by that lower figure if the buyer accepts it. The court does not look for what the seller meant to type, it looks at what the seller actually sent. This objective approach allows commercial parties to rely on the signals they receive. Without it, every agreement could be undermined by a party later claiming they had a secret contrary intention. Formation starts with an offer. Professor Treitel defines this as an expression of willingness to contract on certain terms, made with the intention that it shall become binding as soon as it is accepted. This is distinct from an invitation to treat, which merely invites the other party to open negotiations. In Pharmaceutical Society versus Boots, the court ruled that goods on a shelf are not offers. They are invitations to treat. The offer is only made when the customer presents the goods at the payment point, and the contract is concluded only when the shop accepts that payment. While most advertisements are invitations to treat, the 1893 case of Carlyle v. Carbolic Smokeball Co. proved there are exceptions. The company's ad for a flu remedy was held to be an offer to the whole world. The court noted that the company had deposited £1,000 in a bank specifically to pay claims. This deposit provided objective evidence of their intention to be bound by the terms of the advertisement. Carlyle is an example of a unilateral contract, a promise in return for an act. This differs from a standard bilateral contract, where both parties exchange promises. In a unilateral contract, like an auction without reserve, the offeror is bound the moment the required act is performed. Therefore, an offer is defined by its finality. It gives the other party the power to create a contract simply by saying yes or completing the requested task. Once an offer is made, it remains open for acceptance unless it is revoked, rejected, or it lapses due to the passage of time. In Hyde versus Wrench, a seller offered a farm for £1,000. The buyer responded with an offer of £950. When the seller refused, the buyer tried to accept the original £1,000 price. The court held no contract existed. The £950 counteroffer had permanently destroyed the original £1,000 offer. We must distinguish a counteroffer from a mere request for information. In Stevenson versus McLean, asking about credit terms or delivery dates was held to leave the original offer intact. This creates the battle of the forms in business. If two companies exchange conflicting standard terms, each new document is a counteroffer. Under the last shot rule, the final set of terms sent before the contract is performed usually prevails, as seen in TRW v. Panasonic. Because acceptance must be a mirror image of the offer, any deviation, even a minor one, prevents the contract from forming under those initial terms. Even a mirror image acceptance is ineffective if it isn't communicated. The rule in Entores states that acceptance is only valid when the offerer actually receives it. You cannot bypass this by stating that silence will be treated as consent. In Feldhaus v. Bindley, an uncle told his nephew, "If I hear no more about him, I shall consider the horse mine." The nephew didn't reply, and the court ruled no contract was formed. Silence cannot be imposed as acceptance in a bilateral agreement. This rule protects an offeree from the burden of having to proactively reject every unwanted offer they receive. The major exception to the communication rule is the postal rule from Adams v. Linzels. If the post is a reasonable method of communication, acceptance occurs at the moment the letter is posted, not when it arrives. In household fire insurance for Grant, the contract was formed upon posting, even if the letter was later lost. However, an offeror can prevent this by specifically requiring notice of acceptance. In Hallwell Securities for Hughes, the court decided that by asking for notice in writing, the offeror had impliedly excluded the postal rule. The acceptance had to actually arrive to the effective. The postal rule shifts the risk of a delayed or lost letter onto the offeror. Because this is a significant burden, the law allows the offeror the power to exclude the rule through clear drafting. The final requirement for formation is the intention to create legal relations. Even a clear agreement will not be enforced unless the parties intended it to have legal consequences. The law applies two rebuttable presumptions here. In domestic settings, Balfour v. Balfour presumes there is no legal intent. In commercial settings, Edwards v. Skyways presumes the parties do intend to be legally bound. To win a case, a party must provide evidence to overturn these starting presumptions. Businesses must prove they intended to opt out of legal relations, while families must prove they intended to opt in. We can now apply these rules to resolve the timeline between Paul and John. First, since this is a construction project between a homeowner and a tradesman, commercial intention is presumed under Edwards v. Skyways. On April 14th, John provided a price of £5,000. Objectively, this appears to be a firm offer to do the work on specified terms. On April 15th, Paul replied. While he mentioned a completion date, this was a hopeful inquiry rather than a new condition. Following Stevenson v. McLean, this is a valid acceptance. Now we test for the postal rule. If it applies, Paul's contract was formed the moment he mailed the letter on April 15th. This would make John's cancellation on the 18th legally ineffective. However, John stated he needed to know for sure by April 28th. Similar to the phrasing in Hallwell Securities, this implies that the acceptance must actually reach him. This excludes the postal rule. Because the postal rule was excluded, Paul's acceptance was not valid until it arrived on the 28th. John's revocation was communicated on the 18th, before the contract formed. No contract exists. This scenario demonstrates why top marks depend on identifying ambiguity. The answer hinges on whether John's specific words excluded the postal rule, allowing you to argue both potential outcomes based on the facts provided.